Hello again, here we are with the next term from the C group, CPT, carriage paid to. But before starting, the disclaimer. I'm not a lawyer and lessons given are not legal advice. I'm just sharing my professional knowledge and experiences earned over 2 decades. The quotes we use from the Incoterms 2020 book are all the intellectual property of ICC, International Chamber of Commerce, whom I thank for their effort and perseverance in updating and revising the terms and also permitting us to use the codes. Here you see CPT, meaning delivered, loaded at origin and transported to the named place. Here is the definition in the book. The CPT rule requires the seller to deliver the goods to its carrier but does not indicate whether that is either at the seller's premises, loaded onto the collecting vehicle, or delivered to another premises not unloaded from the seller's vehicle. Why do we need a term like CPT? CPT is useful for several purposes. 1. If we want to drop the carriage and export clearance on the seller in a non-cross ocean shipping, meaning that in air shipment and road shipment, one of the useful terms that we can use is CPT. 2. If we need to use more than one type of transportation. Yes, in combined transportation system, where we have more than one means of transport, we need to use CPT. Imagine that we want to deliver the goods to the buyer after unloading and doing the local transport in a customs house located in the center of a country and away from the harbor or the airport. In this case, because we may have an ocean shipment, then a road transport, and we have two types of transport, we need to use CPT. Or if we want to use the air shipment and then from the airport we need to do the local transport to a place or to a customs house, in this case also we use CPT. In the continuation of this course, you will see that for such a case we have other terms to use, but I should mention that the scope of liability in CPT is different with them. We will see later on. 3. If we, as an exporter, want to get rid of the damage risk in local transport of goods, I mean, we don't want to use FCA, as in FCA the risk of damage in local transport is on the seller. If we want to use CPT for a domestic transport, or we want to deliver the goods to a premises in the country of origin to the carrier, in such case, we use CPT to get rid of the risk in local transport. 4. If the domestic transport includes more than one type of transport. This is the same as the story I told you about the combined transport. As you can see in this diagram, I have showed you the combined transport scenario. In this scenario, as you can see, there is an ocean shipment from the country of origin to the country of destination. As you can see, different from CFR and CIF, in this scenario, the responsibility and the risk transfers to the buyer when the merchandise is given to the carriage company in its warehouse, or when we have the merchandise loaded on our truck ready to be unloaded by the shipping company. But the freight charge here, as you can see, continues up to the point that we have mentioned in our contract as the CPT place. As you see in this case, until the goods are unloaded from the vessel and then transported by a truck in the country of destination as a local transport, the cost is on the seller. The seller is logically obliged to insure the goods for its own safety until the point of delivery. Here is the scenario of air transport in which we use CPT. In this case, as you can see, the merchandise is delivered by a truck to a place nominated by the buyer and the seller as the CPT point. Then the merchandise flies over the distance and the freight charge and the freight cost is on the seller, the same as the story we had in the previous scenario. Again, the local transport in the country of destination is done by a truck or whatever until the point of CPT, and then from that point on the cost is on the buyer. The risk transfer, the same as previous scenario, transfers to the buyer at the point of the delivery when the goods are on truck in the country of origin ready to be unloaded by the carriage company. As you can see, the insurance is empty here, which I have left empty in order to mention that in CPT the insurance document, the insurance policy, is not one of the mandatory documents to present to the customs house or a bank. A1. General obligations. In each of the 11 rules, the seller must provide the goods and their commercial invoice as required by the contract of sale and any other evidence of conformity, such as an analysis certificate or weighbridge document, etc., that might be relevant and specified in the contract. Each of the rules also provide that any document can be in paper or electronic form as agreed to in the contract. Or if the contract makes no mention of this, then as is customary. The rules do not define what electronic form is. It can be anything from a PDF file to blockchain or some format yet to be developed in the future. B1. General obligations. In each of the rules, the buyer must pay the price for the goods as stated in the contract of sale. The rules do not refer to when the payment is to be made: before shipment, immediately after shipment, 30 days after shipment, 30 days after shipment, half now and half later, or whatever, or how it is to be paid: prepayment against an email of copy documents, on presentation of documents to a bank under a letter of credit, or other arrangements. These matters should be specified in the contract. A2. Delivery. The seller delivers the goods by handing them over to its contracted carrier on the agreed date or within the agreed period. There has in the past been some confusion because Incoterms 2000 referred to the first carrier if there were subsequent carriers. In practice, there may well be several carriers contracted in turn by the seller's contracted carrier, such as the truck collecting the goods and taking them to the airport terminal, the cargo handler contracted by the airline to move the goods to the aircraft and load them onto it, the airline itself, and the repeat of these at the other end. But the only carrier of concern is that carrier contracted to move the goods from the point of delivery to the destination. Most importantly, delivery occurs when the seller passes the goods to their carrier to transport them, not when the goods reach the destination. Please be aware that in this case, in case of a CPT, the carriage company, the shipping company, is contracted by the seller, but the responsibility and the risk transfers to the buyer when the goods are delivered. And as you saw in the text, the delivery point is when the goods are transferred and delivered to the first carrier, and the seller has nothing to do with the subsequent carriers or shipping companies. B2. Delivery. The buyer not only must take delivery when they have been handed to the seller's carrier, but also physically receive them at the named place or point within that place of destination. Please keep in mind that in case the buyer refuses to take delivery physically when they are in the destination point, all charges related to returning the products home and demurrage and whatever costs that can emerge from this failure or hesitation will be on the seller. So in order to tackle this problem, as we mentioned before, the seller is advised to buy the contingency insurance for the merchandise. In case the buyer rejects to take delivery when they are in the point of destination, the seller can sue the buyer because according to the regulations, the buyer must take delivery when they are in the destination. A3. Transfer of risk. In all the rules, the seller bears all risks of loss or damage to the goods until they have been delivered in accordance with A2 described above. The exception is loss or damage in circumstances described in B3 below, which varies dependent on the buyer's role in B2. As we said before, CPT is a very flexible form to manage the risk of delivery. B3. Transfer of risk. The buyer bears all risk of loss or damage to the goods once the seller has delivered them as described in A2. If the contract provides for the buyer to inform the seller the time for dispatching the goods or the point of receiving the goods within the destination place and the buyer fails to do so, then the buyer bears the risk of loss or damage to the goods from the agreed date or the end of the agreed period. For example, if the buyer does not inform the buyer where he is to send the goods, how can the seller dispatch them? If the seller has clearly identified the goods, then the risk transfers to the buyer either on the agreed date or the end of the agreed period. Sellers must be careful to take care of such a risk because in some cases, some products will be damaged or unusable if not transferred to a special situation or a special kind of storage. So in many cases, we have talked about the costs of returning the product to the country of origin and so. But in many cases, which have been experienced around the world, the products were damaged and went bad because of waiting in a storage which was not suitable for that kind of product. So in such a case, even if you receive 50% of down payment to tackle the risk, still you have a lot of expenses to compensate. So in case of such products, the sellers are advised to buy Clause A insurance for their merchandise in order to cover such a risk. A4. Carriage. The seller must contract for the carriage of the goods or procure such contract if this is one leg of a string sale. The contract must be from the place of delivery and may be an agreed point within that place. It must be made on usual terms and for the usual route in a customary manner of the type used by the carriage of the type of the goods sold. If the seller and buyer agree on specific matters in regarding the contract of carriage, that is well and good. But if they don't, then the seller must arrange it in the usual manner for those goods. As the seller has to arrange the carriage, it needs to know from the buyer if there is a specific point in the place of destination to which the goods must be transported. For example, if the destination is shown as simply New Delhi, India, where in that large metropolis is the seller's carrier to leave the goods? It could be that it is to be the buyer's premises or a particular location, say in a greenfield building site, or the carrier's premises, or the airport, or the container yard. The exact point should be agreed upon. If it is not, then it is the seller's choice to select the point that best suits its purpose, usually being the cheapest option such as a cargo terminal. If the delivery at the destination is to occur after the buyer completes any necessary import formalities, then the cost of storage due to delays in those formalities being completed is for the buyer, always assuming the seller has provided the buyer with necessary documents in time. The seller must comply with any transport-related security requirements for the whole of the transport to the destination. B4. Carriage. The buyer has no obligation to the seller to arrange a contract of carriage. You should know that in combined transport, when a merchandise enters a territory from a customs house on a harbor to go to a customs house inside the country, inside the territory, there is a custom formality called transit, which needs to be done before the merchandise departs the entrance customs house in the harbor towards the customs house inside the territory. So in the case of any delay in this transport procedure, the cost emerging from warehouse or delays, demurrage, or whatever is on the buyer, not the seller. A5 insurance. The seller does not have the risk beyond the delivery point, so it has no obligation to the buyer to arrange a contract of insurance. However, if the buyer requests at its risk and cost, the seller must provide the buyer with information in its possession that the buyer needs to arrange its insurance. If there is any information which the buyer requests that is not already known to the seller, logically the seller can and probably would choose to assist. Nevertheless, and this is not covered by the Incoterms 2020 rules, a wise seller would investigate taking out marine insurance on a contingency basis. If the goods are lost or damaged in transit, and the buyer therefore refuses to pay for them, in essence breaching the contract, the seller will want to have a fallback of being able to claim on its own marine insurance. B5 insurance. Despite having the risk of loss or damage to the goods from the delivery point, the buyer does not have an obligation to the seller to insure the goods. Whether the buyer chooses to insure the goods or bear the risk themselves is entirely their choice. A6 delivery transport document. The seller must provide the buyer with the usual transport documents for the transport contracted in A4 if it is customary or the buyer requested it, and at the seller's cost. As CPT and CIP cover any mode or modes of transport, what form that document of transport takes will be dependent on the mode or modes used. If the modes include carriage by sea, such as in FCL or LCL transactions, then it is usual for the seller to obtain a sea waybill or bill of lading. If the latter is used in a negotiable form and in several originals, then a full set of those originals must be presented to the buyer, sometimes through the seller's bank to the buyer's bank under a letter of credit. If the mode includes the goods going by air, then typically an airway bill will be issued, and if requested, the seller will be given one original for shipper, but this is not a negotiable transport document. Shipments by truck might involve issue of a CMR in Europe or simply some form of consignment note or truck waybill, and these two are not negotiable. Shipment by rail similarly will usually be covered by some form of rail consignment note that is not negotiable. Yes, we mentioned the negotiable documents here. Negotiable documents are documents which you can sell the products when you have them in hand. That's why in the case of an airway bill, the non-negotiable form is given to the seller. The transport document must cover movement of the contracted goods within the agreed period of shipment. If it is agreed, then this document must enable the buyer to claim the goods from the carrier at the named place of destination, and in a string sale enable the buyer to sell the goods in transit to a subsequent buyer by transferring that document. This would usually be in the form of a negotiable bill of lading. B6 delivery transport document. The buyer must accept the transport document provided by the seller so long as it is in conformity with the contract. A7. Export-import clearance. This rule, like all the multimodal rules, is suitable for both domestic and international transactions. Where applicable, the seller must at its own risk and expense carry out all export clearance formalities required by the country of export, such as licenses or permits, security clearance for export, pre-shipment inspection, and any other authorizations or approvals. The seller has no obligation to arrange any transit import clearances. However, if the buyer requests at its own risk and cost, the seller must assist in obtaining any documents and/or information which relate to formalities required by the country of transit or import, such as permits or licenses, security clearance for transit import, pre-shipment inspection required by the transit or import authorities, and any other official authorizations or approvals. B7. Export-import clearance. Where applicable, the buyer must assist the seller at the seller's request, risk and cost, in obtaining any documents and/or information needed for all export-related formalities required by the country of export. Where applicable, the buyer must carry out and pay for all formalities required by any country of transit and the country of import. These include licenses and permits required for transit, import licenses and permits required for import, import clearance, security clearance for transit and import, pre-shipment inspection, and any other official authorizations and approvals. They are the buyer's responsibility because they occur after delivery by the seller. At first glance, it might seem strange that both seller and buyer have responsibility for pre-shipment inspections. To clarify, the seller is responsible if it is a requirement of the country of export, and the buyer is responsible if it is a requirement of the country of transit or import. Please be aware that in many cases, the seller needs some documents from the buyer to export the documents from the country of origin, and on the other side, the buyer needs some documents or information from the seller to do the import formalities in the country of destination. If we have a product to export or import with this kind of specification, so we need to specify everything and clarify everything in the contract of sale. Because in case you are the buyer and the seller tends not to help you, and if there is no obligation for the seller to do this, then the seller can hesitate. Or if you are a seller and the buyer has no obligation in the contract of sale to provide this kind of information for you to export the goods smoothly, then you may have problems. So if you need, please specify this in the contract of sale in order to put the liability on the other party. A8. Checking, packaging, marking. In all rules, the seller must pay the cost of any checking operations which are necessary for delivering the goods, such as checking quality, measuring the goods and/or packaging, weighing, counting the goods and/or packaging. The seller must also package the goods at its own cost unless it is usual for the trade of the goods that they are sold unpackaged, such as in the case of bulk goods. The seller must also take into account the transport of the goods and package them appropriately unless the parties have agreed in their contract that the goods be packaged and/or marked in a specific manner. Please keep in mind that the seller might not be aware of the way you want to transport the parts in your own country and whether the people working in the transportation process follow the needed standards to transport a specific product. You know that in transport industry there are different type of people working and there are different types of standards. So in some countries, the people working in the transportation systems behave and treat the products a bit harshly. So if you see such situation in your country, or if you see such situation in the country of origin, you can ask the seller to go beyond the standard export packing and make the packaging a bit stronger. I have used this several times in my career, and I have asked especially for the machinery for a better packaging and for a stronger packaging in order for my products not to be damaged during the transport. B8, checking packaging marking. In all rules, there is no obligation from the buyer to the seller as regards packaging and marking. There can in practice, however, be agreed exceptions, such as when the buyer provides the seller with labels, logos, or similar. As I have mentioned before, in case of any delay because of these items coming from the buyer, the delay will be on the buyer, and any kind of delay and compensations will be on the buyer. A9, allocation of costs. The seller must pay all costs until the goods have been delivered under A2. Other than any costs, the buyer must pay as stated in B9. Transport costs resulting from the contract of carriage, including costs of loading the goods and any other transport-related security, must be paid by the seller. The cost of providing the buyer proof of the goods being delivered are also for the seller. If the contract of carriage includes unloading at the agreed destination, which would typically be the case in most shipments, the seller must pay these. Additionally, any costs of transit included in the contract of carriage must also be paid by the seller. The seller must pay any costs involved in providing the usual proof that the goods have been delivered. I mean the POD, proof of delivery. So if the contract between the parties state that proof as being a transport document, then the carrier's document fee is for the seller. The seller must pay any costs, export duties and taxes, where applicable, related to export clearance. If the buyer is requested by the seller to provide information or documents in relation to export clearance, then the seller must pay the buyer for these costs. As you see here, CPT is a flexible term in terms of cost allocation. You can see that in many cases in CPT, the unloading at the destination is on the seller, which is a kind of flexibility, and in many cases the seller can avoid accepting this cost, depending on the situation and the seller's policy for its transaction. B9, allocation of costs. The buyer must pay the seller all costs relating to the goods from when they have been delivered, other than those payable by the seller. If the seller has been requested by the buyer to provide assistance in obtaining information or documents needed for the buyer to effect insurance and import formalities, then the buyer must reimburse the seller's costs. Where applicable, the buyer must pay any duties, taxes, and other costs for import clearance. The buyer must pay for unloading costs unless they were paid by the seller under the contract of carriage. The buyer must pay for any cost of the country of transit unless they have been paid by the seller under the contract of carriage. A10, notices. The C rules, as we have seen before, involve two distinct points. This is reflected by the requirements that the seller must give the buyer notice that the goods have been delivered as required in A2, and any notice the buyer will need enabling the buyer to receive the goods. The manner in which this will be done is usually detailed in the contracts, such as by a simple email and/or copies of shipping documents being emailed. B10, notices. If the parties agree in the contract that the buyer is entitled to determine the time for the seller to deliver the goods, and possibly more importantly, the point within the named place of destination where it will receive the goods, the buyer must give the seller sufficient notice. The contract will usually detail how much notice is to be given, and this might vary with the modes of transport. Also, this might vary with the type of the product and with the type of the transportation. You may know that some special products need a special kind of transportation, such as the products which need to be transported in a refrigerated container. So in such a case, delivering the product to the point needs some infrastructure for the products to be delivered. So as the buyer or as the seller, you have to be aware of this situation for some special products. Again, as we mentioned before, if any of the parties fail to give sufficient notice to the other party and the other party fails to do its own liability because of that failure from the other side, then the cost emerging from this failure will be on the party which has failed to give sufficient notice to the other party. Points to keep in mind. CPT is a widely used term and also a good one for any mode of transport, but you have to be careful about some items. In CPT, the delivery takes place when the goods are handed over to the shipping company. Even if the seller contracts the shipping service, it is not liable for any damage after the delivery. And as we mentioned before, when we say shipping company, we mean the shipping company which is the first leg of the transport. In case of a string sale, the delivery point cannot be considered as to be the second or the third leg of the shipment, only the first leg of the shipment, the first carrier who receives the products from the seller directly. 2. In this term, the point of delivery is not mentioned as the seller is handing the merchandise over the carrier whom it has contracted itself. So buyers must clarify the point of delivery in the contract to consequently clarify when the risk is transferred. It can be in any point before the international shipment. 3. In CPT and CIP, the same as CFR and CIF, the seller is not responsible if the goods are damaged during the international shipment or never reach the destination, so the buyer must be careful about the insurance. 4. If the buyer fails to collect the goods at the destination, all the demurrage, detention, THC, and other charges will be on the seller. In order to prevent such a loss, the seller is advised to buy a contingency insurance. 5. CPT is a bit different as for the allocation of cost. I mean, if we say CPT named CY container yard in the port of loading, then the loading costs will be on the buyer, and if we say CPT named customs of destination like inland customs, then the unloading, THC, and all other costs up to that point of destination is on the seller. 6. CPT and CIP, the semi-identical twins of our story, are not so wanted by the banks in case of an LC. This is because the delivery place, port of loading, port of discharge are not clearly defined in these terms. 7. This term is a good choice for a letter of credit. Yes, you can feel a contradiction between 6 and 7. It is not liked by the banks, but for the seller this is a good term because there is much flexibility in this term to play with for the seller. 8. If the term is CPT named destination, then the buyer must make sure the freight is paid by the seller. So the clause in LC which mentions the BL or AWA bill as a shipping document must clarify this. For example, bill of lading marked freight paid to Port of Mersin, Turkey. 9. The Incoterms rules skip when the title passes from the seller to buyer. This needs to be defined separately in the sales contract. For example, if you want to pass the title to the buyer at the delivery point, you must mention this in the contract.